From Washington is recognized, and then the gentleman from North Carolina.
Thank you, Mr. Chairman. Mr. Smith, thank you for coming here today. Your willingness to speak directly to us and to the American people about your investigation is professional, it's courageous, and it's patriotic. It's high time that the American people hear directly from you about the results of your investigation of President Donald Trump for his criminal actions leading up to and the day of January 6th, 2021. The facts, according to your report, are simple. Without a single piece of evidence, Trump sowed doubt about the 2020 election results and urged his followers to, quote, walk down to the Capitol and fight like hell on January 6th. And that's exactly what they did. Thousands of insurrectionists violently tried to stop Congress from certifying the 2020 election and doing our duty.
We need to talk about the architecture of a lie. Not just any lie, but a foundational falsehood that is currently sustaining the political viability of Donald Trump. There is a chasm opening up in this country, a dangerous disconnect between what is demonstrably factually occurring inside American courtrooms and the hallucinatory version of those events being fed to millions of people at rallies and in fundraising emails. We are witnessing a former president systematically construct an alternate reality where he is not a criminal defendant being held to account, but a conquering hero dismantling a corrupt system from within. The problem is, the court transcripts tell a radically different story, one of a man who is losing, panicked, and increasingly impotent in the face of the rule of law. When you strip away the noise, the social media blasts, and the rally rhetoric, and you look solely at the certified records of judicial proceedings, a stark picture emerges. Trump tells his base that judges are crumbling before him. He describes scenes where jurists are flustered by his brilliance, unable to handle his commanding presence, storming out of their own courtrooms in frustration because they cannot contain him. He paints himself as the immovable object, the dominant force that makes the legal system bend to his will. His supporters consume this narrative voraciously. They revel in the image of their leader standing tall against what they've been told is a weaponized judiciary, humiliating corrupt judges and exposing the sham. But this entire narrative structure is a complete fabrication. It is not merely a spin on the truth, it is an inversion of reality. The forensic evidence from inside these trials, the minute-by-minute logs, the judge's orders, the eyewitness accounts from seasoned legal reporters, proves that the exact opposite is happening. Judges are not walking out on Donald Trump is walking out on them. Judges are not losing control. They are methodically, calmly, and ruthlessly exerting control over a defendant unused to being told no. They are cutting him off mid-sentence when he violates procedure. They are threatening his attorneys with incarceration. They are issuing 5-figure fines and tightening gag orders. They are grinding his legal defenses into dust and moving these cases steadily toward verdicts, regardless of his tantrums. To understand the depth of this deception, we have to conduct a forensic autopsy of the specific incidents where Trump's mythology collided with courtroom reality. We need to look at the mechanics of how he tries to turn crushing legal defeats into public relations victories. Let's begin with the second E. Jean Carroll defamation trial in early 2024. Remember the context. A jury had already found Trump liable for sexually abusing Carroll and defaming her. This trial was solely to determine how much more he owed her for continuing the attacks. Trump's presence there was voluntary. He didn't have to attend civil proceedings, but he chose to use the court as a campaign prop, an arena to project defiance. The reality inside Judge Lewis Kaplan's courtroom was disaster management for the defense. Trump's attorney, Alina Habba, was outmatched and under siege. According to court transcripts and reporting from those present, Habba repeatedly attempted to violate basic rules of evidence. She tried to relitigate issues Judge Kaplan had already decided were closed. She ignored explicit judicial instructions. This isn't just bad lawyering. In a federal courtroom, it's flirtation with disaster. Judge Kaplan, a no-nonsense jurist who runs a disciplined court, ran out of patience. The dynamic wasn't a judge flustered by brilliance. It was a seasoned authority figure disciplining an unruly officer of the court. Kaplan began issuing stern warnings to Habba. When she persisted, he escalated to the ultimate threat a judge holds over an attorney: contempt of court. He explicitly stated that if she continued to ignore his rulings, she would face sanctions, up to and including jail time. Let that sink in. A federal judge was threatening to lock up the former president's lawyer in the middle of a high-stakes trial. The climax of this disaster occurred during the plaintiff's closing arguments. E. Jean Carroll's lawyer was delivering the final summation of damages to the jury. It was a critical moment, requiring the defendant to sit and face the consequences of his actions. Trump couldn't do it. In the middle of the closing argument, right after his lawyer had been threatened with incarceration, Trump abruptly stood up and walked out of the courtroom. He didn't ask permission. He didn't wait for a recess. He fled. To the jury and to any objective observer, this was not a moment of strength. It was an admission of weakness, a fight-or-flight response triggered by a complete loss of control in the environment. He was running away from a closing argument he couldn't stomach and a judge who had just neutered his legal defense. Yet hours later, the spin machine was activated. Trump replayed this moment to his base not as a retreat, but as a strategic power move, a defiant statement against a rigged system. He took an act of cowardice and repackaged it as heroism, knowing his followers would never read the transcript that showed he left just as the legal walls were closing in on his attorney. The jury, incidentally, was unimpressed by the theatrics. They hit him with an $83.3 million judgment. We saw this same pattern of inversion in the New York civil fraud case presided over by Judge Arthur Engoron. This was the months-long bench trial concerning the systemic inflation of Trump's assets to defraud lenders and insurers. The tension in that courtroom was palpable for weeks, but the breaking point came during closing arguments. In New York, defendants sometimes have the leeway to give a personal closing statement, but it is a privilege granted by the judge, not a right, and it comes with strict guardrails. Judge Engoron was explicit with Trump's legal team. If Trump wanted to speak, he had to agree to the rules. He could not deliver a campaign speech. He could not attack the judge, his staff, or the attorney general. He could not re-argue facts that had already been decided against him. He had to address the specific legal issues remaining in the case. Trump refused to agree to these parameters. He demanded carte blanche to turn the courtroom into a MAGA rally stage. Judge Engoron, correctly applying the law to prevent the proceedings from descending into chaos, denied the request. He ruled that if Trump wouldn't follow the rules, he wouldn't speak. But Donald Trump does not accept silence. During his lawyer's legitimate closing argument, Trump simply stood up and began speaking anyway. He launched into a blistering off-script diatribe. He called the entire case a fraud. He attacked the judge. He claimed political persecution. He violated every single condition Judge Engoron had laid out. What happened next is crucial to understanding the reality versus the fiction. Judge Engoron did not cower. He did not get flustered. He let Trump ramble for perhaps a minute, likely to create a record of the defiance, and then he shut it down with the cold authority of the bench. He cut the former president off mid-sentence. He told Trump's lawyer to control your client. When Trump persisted, the judge ordered a recess, effectively silencing the outburst by removing the audience. Trump was not silenced because the judge was afraid of his words. He was silenced because he was behaving like a petulant child incapable of following adult rules in a serious setting. Yet, later that day, the narrative was spun. Trump and his allies portrayed Engoron as weak, claiming the judge was so overwhelmed by Trump's truth-telling that he had to flee the bench and call a recess to compose himself. It's a grotesque distortion. The judge exerted total control. The defendant was humiliated by being publicly silenced by a higher authority. The deception isn't always about dramatic confrontations. Sometimes it's about inventing drama where none exists to keep the donation money flowing. Consider the Manhattan criminal trial, the hush money election interference case that resulted in 34 felony convictions. Throughout those weeks in that dingy Manhattan courtroom, the Trump campaign sent out a deluge of fundraising emails. These missives described wild courtroom spectacles, explosive confrontations, and a defendant heroically battling a totally corrupted process. If you only read the emails, you'd think it was a daily cage match. But if you read the pool reports from journalists actually inside the room, from CNN, PBS, the major wires, the reality was mind-numbingly mundane. Criminal trials, especially white-collar ones involving financial records, are tedious. There were hours of authenticating phone records, entering checks into evidence, and technical cross-examinations. There were no explosions. There were no dramatic walkouts. The most notable behavior from the defendant was that he frequently appeared furious, bored, or was actively falling asleep at the defense table. Trump needed to keep his base agitated and engaged. He couldn't raise money on the reality of a sleepy defendant watching a slow procedural grind toward conviction. So, his campaign invented a fictional version of the trial, a daily soap opera of persecution and defiance that bore almost no resemblance to the events unfolding under Judge Juan Merchan's watchful eye. And let's talk about Judge Merchan. Trump's team threw everything at him. They filed endless motions for mistrial, motions for recusal based on specious claims about his daughter, motions to delay, motions to suppress evidence. Merchan systematically, methodically denied almost every single one of them. He called their arguments meritless. He issued strict gag orders to protect witnesses, jurors, and court staff from Trump's stochastic terrorism. When Trump violated those gag orders, attacking witnesses and the jury pool on social media, Merchan didn't buckle. He held the former president in criminal contempt 10 separate times. He fined him thousands of dollars. Crucially, he looked Donald Trump in the eye and warned him, on the record, that further violations could result in incarceration. Judge Merchan wasn't losing control. He was applying a progressive discipline structure designed to bring a recalcitrant defendant to heel. The trial proceeded entirely on the judge's schedule, under the judge's rules, and it ended with a jury of 12 ordinary citizens delivering a unanimous verdict of guilty on all counts. The patterns here are undeniable and terrifying. Why does this matter? Why spend so much time dissecting the gap between the rally speech and the court transcript? It matters because this is not just standard political spin. This is a calculated psychological operation designed to insulate Trump's supporters from reality. Trump knows he is losing. If he were winning in court based on the merits of the law and the evidence, he wouldn't need to lie. He would happily stand outside the courthouse and wave the judge's favorable rulings around. He cannot do that because those rulings do not exist. He is losing on every front. He has been branded a sexual abuser by a jury. He has been found liable for massive business fraud. He is a convicted felon. He is facing hundreds of millions of dollars in penalties and fines that threaten his entire business empire. The objective reality of his legal situation is catastrophic, because the truth is too devastating to admit, and because his political brand is built entirely on the myth of the invincible strongman. He must construct an alternative narrative. He has to invent a world where he is the victim hero, where the judges are cartoon villains, and where the entire legal system is collapsing under the weight of its own corruption, exposed by his bravery. The danger is that millions of Americans are living inside this fabricated reality. They believe the lies because they have been conditioned for years to distrust any source of information outside the MAGA ecosystem. They don't read court transcripts. They read Trump's Truth Social posts. They don't watch C-SPAN. They watch influencers who regurgitate the campaign's talking points. When you convince a massive segment of the population that the judicial system is illegitimate, you are dismantling the rule of law. You are priming a population to reject any verdict, any judgment, any accountability that falls upon their leader. This is why we see threats against judges escalate. This is why courthouses require fortified security. Trump is teaching his followers that the courts are not neutral arbiters of fact, but enemy territory to be conquered or destroyed. But here is the hard truth that Trump is desperately trying to outrun. Propaganda has a shelf life in the face of legal enforcement. You can lie about winning right up until the moment the marshal arrives to seize the assets. You can claim the judge is scared of you right up until the moment the handcuffs click shut for contempt. Trump is currently living in the gap between judgment and enforcement. He is using that time to flood the zone with falsehoods, hoping to regain political power before the consequences of his legal defeats become physical and undeniable. But the system is grinding forward. The appeals will run out. The stays will be lifted. The fines will become due. When the properties are put up for auction to satisfy the state of New York, when the liens are placed on his bank accounts, when he faces potential sentencing in a criminal court, the strongman narrative will collide violently with reality. It is impossible to spin asset seizure as a victory. It is impossible to spin incarceration as dominance. We are watching a slow-motion collision between a master illusionist and the immovable object of the law. Trump's entire defense strategy now relies on maintaining this illusion long enough to subvert the system that is holding him accountable. Our job is to look at the transcripts, ignore the shouting, and prepare for the moment when the illusion finally shatters. This isn't the last chapter of this story. When the next move happens, when the enforcement mechanisms begin to turn, you'll need to understand what you're actually seeing versus what you're being told. Subscribe so you're not caught off guard when it matters most.